And we'll go ahead and reconvene from executive session. Today is Wednesday, November 12th, 2025, and it is 8:48 p.m. Members of the court are present and ready to proceed with actions on, if any actions are being taken on the items that have been discussed in executive session. Go ahead and begin with item number 13. Amendments to the Maverick County purchasing policy and questions on the legal concerns regarding that. Mr. Grove, I'll ask you to go ahead and proceed on the discussions of the court and those legal concerns on those matters. I don't know if we can look at that from a red line perspective.
Yes.
Proceed from there.
So y'all asked for legal advice on the changes to the law and how it's going to be affecting the purchasing policy and also the interplay the way the Maverick County structure currently is. So what we reviewed, we'll go over now. As far as relationships go, starting out from statement of purchasing policy on page 4, nothing in there has changed. I've got the most current version. I will send it to you after this. Wasn't able to print it out, but we'll go over it. Let's see, starting at relationships and then going down to requisitions will all stay the same. Nothing has changed there, but purchasing policy is where the big change is coming from. Different numbers in there. So y'all are looking at 3 point, starting at which number?
So this is page
5.
Is that 5? Is that correct?
Yes, sir.
Okay.
3.1.
So yes, so looking at it, 3.2 was removed at the request last time. So 3.2 and 3.3 are gone. Those will not be applicable. Looking at, so once you remove those, going down to 3.6.
What? 3.1? You made some changes to 3.1 in regards to contracts. Is that correct?
Yes. So currently, yes. So there's a bold statement that says these purchases, starting at the very last sentence, 3.1, a sentence will be added as follows. These purchases must be reviewed by purchasing, legal, and certified by the auditor, which is currently the process. After y'all adopted the amendment to authorize the county judge to execute purchases under 50, that will go up to 100 based on the new law change. To ensure that all purchases are legal and authorized by law.
And these are only purchases that are related to a contractor, correct? Or
These are purchasing.
Purchases in general.
Just standard in general?
Anything that's going to require contract, anything that will require contract for services or good or anything like that. Anything that will require contract. So looking down, going to section 3, this would be 3.6. In yours, it is going to be 8, I think is where it was.
3.3 and 3.4.
Yeah, those were gone. So mine will say, sir, purchase orders will be prepared. Starting with that one, I think it's y'all's 3.8.
3.8.
So it's now 3.6. Will be prepared by the using county office, submitted to the county judge for approval, and then submitted to purchasing for review and issuance. My understanding that is currently y'all's process.
Correct.
Yes.
So that is a reflection of the current county process. So moving down to y'all's section 3.10, I think it was. So it's now 3.8, selection of a vendor. So that will now read, selection of a vendor on non-bid purchases rests exclusively with the using county office. Is that correct?
Correct.
Yes.
Okay. So that was the change there. Under section 4 for purchase orders, we discussed blanket purchase order. Y'all would like that language to remain.
Correct.
Yes.
Yes.
Okay. That all of that language will stay. Got it?
Okay.
Okay, going down to page starting purchase process. Page on yours it will be page 11.
11.
So all of that is changed to where it's purchases of 100,000 or more.
Hang on, sir. I lost you there.
It's on page 10.
So it's on your page then? Okay.
Yes, that's
Sorry.
where I was lost.
There's
Yes,
a
sir.
section
Page
break
10.
on here that shouldn't be
On the
there.
purchase process.
Yeah, so it's your page 10. I apologize. There's
Okay.
a section break that got moved. So that, in accordance with the new update that went into effect September 1st, the competitive bidding threshold is now 100,000. Is no longer 50,000. So that has changed.
Mm-hmm.
There is no longer a requirement to go out and get 3 bids as previously, as it was in your previous policy. That has been removed. So anything that says purchases from $1 to $2,400 to $2,499 is gone. Purchases from $2,500 to $9,999 is gone. Purchases of $10,000 to $50,000, that section is also removed. You will not be required to submit 3 separate quotes any longer. This is in accordance with current law, state law. Okay. Any questions?
No, so I do, may I judge?
Mhm.
So on purchases, we no longer need to go out and get 3 quotes.
No.
Or bids. We just
Competitive
write the
bidding
PO.
is encouraged. It will always be encouraged.
Okay.
We talked about an executive with permission. Can we talk about RFQs? Okay, so ideally you want to submit, if you want to have, you're going to have different kinds of projects. RFQs for on-call contractors is a good way of doing that. That way you have competitively bid it out. Even if it's not going to reach that $100,000 threshold, it gives every contractor the opportunity to bid on county work.
Okay.
I would recommend doing that kind of process going forward. That way people do get to competitively bid on work for the county. That is the ideal scenario.
Okay.
Some kind of process where everybody gets a chance to bid.
Okay.
For the work.
Which is what we have.
Mhm.
We have that in place, right?
Okay. There are no other changes there. Looking down to exemptions from the requisition/purchase order process. And the second bullet point, emergency purchases. After damage to public property, after that sentence ends, I've added the sentence, the office requesting the emergency purchase must notify the county judge for approval of the purchase. Period. After approval by the county judge, the office shall submit the purchase order within 3 days, within 3 business days after the emergency purchase has passed. After the emergency has passed, sorry. That reflects the current process that the county already has.
Correct.
Is that correct?
Yes.
Competitive bidding process.
Was it?
Competitive bidding.
So go down to your page
13.
13.
13. 13 or 14. Okay. Competitive bidding process. So, section 1, subsection C, 1C. Starting after be written on technical or functional basis. The next sentence, the next 2 sentences, the use of brand names and specifications is discouraged, but may be used for comparison purposes only. When brand names must be used, it will be stated or proved equal. Those sentences have been removed. Is that correct?
Correct.
Yes.
Yes.
Everything else is staying the same. I've done a couple of cleanup things where I've just changed capitalized county throughout, changed department to office to match the manual policy, and that is it for substantial changes within what's currently there. Are there any questions, concerns?
Yes. May I do it?
Yes.
I just want legal to clarify on purchase orders that require a contractor. You're gonna have a standard contract already
Yes, ma'am.
given to us so that we can fill it out and
Yes.
attach it to the purchase order.
Yes, ma'am.
Is that correct?
Yes. And if you would like to include language about project managers overseeing that project, I would recommend it. That way somebody is overseeing the project to make sure the work is being done in accordance with the project. So let's say Road and Bridge is doing a project and there's a contract for services. I would highly recommend somebody oversee that project to make sure that it's done. That way, whenever the invoice is submitted, there's proof that the work was done in accordance with the contract that
So-
was done.
If it's a road and bridge job, will the road and bridge supervisor can oversee the
They
project?
should be the only person overseeing the project.
Thank you. I just wanted clarification on that to make sure that we're on the same page.
It's the county road and bridge department. They are the only ones who should be overseeing road and bridge work.
Okay. Okay.
Any other questions?
Where's that fitting in?
They should be the ones controlling the work, telling the contractor where to start, when to stop. Nobody else, unless it's been delegated by commissioner's court under a contract or that contract specifically has a project manager on there.
So the road and bridge supervisor has the jurisdiction to start and end a project.
That's the one. So in the contract, it'll say with a copy to is he's the delegated. He or she will be the delegated representative for that department for that contract.
Okay. Okay.
And within the policy, of course, that's within the policy that's dictated under what section?
What section?
That was a question.
It will be in the contract, but it does nothing in this policy authorizes a county department to interfere with another county department's work,
Okay.
and that's also Texas law,
Okay.
unless they have specific authority to do so.
Sir, I don't think there's no changes whatsoever on number 2, professional services, which is page 14 for us.
Okay.
There's no changes in there on professional services.
No. Do you want to make changes to professional services? Do you have concerns that need to be addressed?
I have no problem with that the way it is.
Not at this point.
Professional services are an area that you're hiring that person because they're very skilled for
Sure.
their specific profession, right? So that's why you're putting it out to RFQ or RFP.
Yes.
And in fact, you want them making sure that it's done in accordance with the specs. You want the architect or the engineer overseeing that project. So they're the ones who control the work to make sure it's done in accordance with the contract.
Okay.
So then clear on there for the professional services, and I mean, I know that I shouldn't have to say this, but on section 2.1A, examples of professional services include accounting, auditing, architecture, economics, engineering, financial advisory services, law, laboratory services, consulting, medicine, and surveying.
Surveying.
Can we add on there just to name a few?
So
Because on that purpose, for those matters, that has been something I think they wanted to remove in order for them not to just have those, because then they can interpret that those are the only ones that are going to be determined as professional services,
But it says et cetera.
etc.
Et cetera.
I understand that, but
Mhm.
my concern is how we can clarify that for them. You know, this was brought up in the last.
okay, so
They wanted to remove this.
I understand. So what I will say is professional services, there's a specific chapter in the government code. It's 2254. Let me verify that that's correct. But that has a definition of professional services. And so that's kind of copying, parroting exactly what's in that chapter. Now, if it's if there's a professional service that doesn't necessarily fit that definition, but it's highly skilled or qualified, it's a professional service, there's also a discretionary exemption under 262.024 that the court can grant a discretionary exemption to for professional services. So there is still a caveat, right? There is, because there will be things that aren't listed. That law hasn't been updated in years.
Of course.
So you'll still have that ability to do that.
I have no issue with it from our end. I mean,
Okay.
I understand that I can open up the state statute and read what it is, but there's another department that obviously doesn't do that.
Well, ultimately, then it does say this in the policy, purchasing decisions belong to Commissioner's Court.
May I just,
Yes, Commissioner.
an example is a professional landscaper, designer. Will it be
Architectural landscape.
That is actually, it is mentioned as one of those, it's in the occupations code.
Because that's been rejected in the past.
It depends on what the service is, but that is actually defined in the
A master
occupations
plan
code.
for a landscape.
There's a landscape architect. It depends on what we're talking about for landscape architect, and I can get to that specific definition. So there is, under chapter 1052, occupations code is landscape architects.
Well, they don't have the title of a landscape architect. They have a professional business where they go out and design master plans for XXX.
Well, according to this, they have to. According to this law, a person may not engage in the practice of landscape architecture unless the person holds a certificate of registration under this chapter, or the person holds a license or permit issued by the Department of Agriculture, is a building designer, is a landscape contractor, is a landscape designer.
Which
all
is a
those
landscape
Which
contract.
means-
That's what it is.
then they're not required to have a license.
Thank you.
Anything?
I mean,
Are there any other questions?
Judge and I can read the
Well, I think we all can here. It's just
Let's continue here.
anything else.
I'm gonna want a copy of the minutes.
Make sure that that's reflective.
No.
For the record, and on this item, Miss Irma, I'm going to ask that this be verbatim. Okay,
Please.
on the minutes.
But we're gonna get a copy from you.
There are certain things. I know this has come up in the past. There are certain things that for certain projects, you do have to have an architect or engineer overseeing it if you're making modifications to public buildings. There is that is a state law requirement.
Public buildings.
Anything owned by the county over a certain dollar amount. So 1 second.
Okay,
Anything else?
thank you. No.
Anything further, Mr. Grove?
No. If y'all don't have any other questions, I will submit this final. So if you would like to adopt this policy, adopt it with the changes we've discussed. And that's your new policy.
I so move that we adopt the purchasing policy as with the changes that we currently made.
There's a motion by Commissioner Ramos. Is there a second?
Second.
Second by Commissioner Rios. Discussion?
I just want to make sure that whatever we discuss here, it is exactly what you want from it.
Exactly.
Yes,
Mhm. And as always,
it's
the
required.
policy is a living document. Policies can be
If
modified.
When you come up to make modifications, then you can definitely bring it back. And again, this doesn't, and just so we're all on notice, right? You still have other state law that govern purchases and conflicts of interest disclosures and certificate of interested parties. All of those things are still applicable and will always still be applicable. You still have to follow law when making purchases. Nothing is changing there. That's still a requirement for all county employees. And the other difference here too, though, is in there too. Whatever the elected official or department head that's going to be making purchases has to sign an acknowledgement that they have read and understood this purchasing policy, and that chapter, file that with you. So violations of this purchasing policy are Class C misdemeanors and possibly Class B. So, we talked about doing a rollout purchasing training in the future.
It's necessary.
It is necessary because whoever's going to be doing it needs to file that with that acknowledgement, or they cannot be making any purchases. And if they do, they're in violation of law. Technically, they would already be in violation of law if they're making a purchase or contracting, binding the county without specific authority to do so. There are certain people that don't have to for certain contracts. The sheriff's office would be one for commissary purchases, those kinds of things. But those specific exceptions are statutory, so that will fall outside of this. This is for, generally speaking, all county business related. So, any other questions?
No, any other questions? Not, there's a motion and a second. There's no further discussion. Call for the question. All those in favor, please raise your right hand. Unanimous. All right. Moving forward, item number 2021. In regards to the Maverick County Auditor's Office retaining the law firm of Sanchez and Wilson for professional services. The contract for said services as ordered exempt from competitive bidding pursuant to section 2622024 of the Texas Local Government Code, authorizing the Maverick County Auditor to execute the contractual agreement with the law firm of Sanchez and Wilson PLLC.
Judge, I so move that we approve item as presented.
There's a motion
That is
made.
my motion.
Motion has been made by Commissioner Morales. Is there a second?
If that's what they want.
I
Second.
I make a second for the sake of discussion.
Discussion. Okay. Motion. There has been a second made by Commissioner Reese. Discussion. Did you have discussion on this, Commissioner?
That's my second.
Did you have any discussion on the matter?
Yes,
Okay.
I have some discussion.
Go ahead.
I just want to make sure that the hiring, can we? I thought I saw an X amount of money that will be paid to this firm.
No, I think that it cannot exceed $10,000 because that's the only amount allocated under her professional services.
That's what she's got.
Yes.
Cannot exceed that. That's correct.
Okay.
I reviewed that contract and I see no issues with it. It's
Okay, that's the amount that she
She
can
has-
use for that particular purpose.
my understanding she has the funds budgeted for professional services.
Further discussion? If not,
It's their funds.
I'll call for the question. Those in favor, please raise your right hand. Those in opposition?
I'm against.
There's 3-2 on this issue. Is that correct?
3-2.
3 in favor.
Very well. So on that matter, let the record reflect that there will be the motion, of course, passed. Moving forward, we'll go ahead and move to the next on the item number 1 of the executive session, 28-1. For this purpose, funding obligations for fire and EMS interlocal agreement. And Mr. Grove,
After discussion, I would recommend you authorize it upon council to prepare all necessary, to take all necessary action to get the funding obligations going.
is there a motion to that effect?
So move, Judge.
Motion's been made by Commissioner Reese. Is there a second?
Second.
Second by Commissioner Ramos. Discussion? Being that there is none, all those in favor, please raise your right hand. Unanimous. Moving on to item number 28-2, county reimbursements of legal expenses.
I recommend no action at this time. It will be brought to another commissioner's court. It will be brought to the next court.
Very well. No action at this time. Moving forward, for this purpose then, if there is nothing further, we taking care of all items, Ms. Seymour? Yes? Is there a motion to adjourn?
So moved.
Motion's been made by Commissioner Morales. Is there a second?
Second.
Second by Commissioner Ramos. Discussion. Being that there is none, all those in favor, please raise your right hand. Unanimous. Thank you all very much.